hours into what should have been just a routine flight, high above the vast, dark expanse of the Pacific Ocean, chaos struck. I mean, picture this. You're cruising at 36,000 feet, maybe watching a movie, maybe trying to sleep, and then bam, without any warning, the plane just plunges.
Not just a little bump either.
No, not at all. A sudden, really violent drop. Everything not bolted down, just flying. Passengers later described the terror. One said the plane must have dropped about 100 feet or something because we all went up to the ceiling.
Imagine seeing that.
And another person added this, just chilling detail, literally bodies on the ceiling of the plane. Seatbelts maybe failed some people or they weren't wearing them, and loose items just became projectiles.
Yeah, terrifying. Seatbacks snapping, oxygen masks dropping down.
Right, dangling kind of uselessly in all the panic. It wasn't just turbulence, it was, well, pure airborne terror.
And for many on that Air Canada flight, AC-33, back in July 2019, including a mother and daughter, Renae and Stephanie Evans, that terror was really just the beginning, wasn't it? The start of a very long and painful journey.
Exactly. That awful incident over the Pacific, it wasn't the end of the story for the Evans family. It was like this shocking prologue to this really intricate legal drama.
Yeah, drama that involved not just, terrible injuries, but also the fine print in international contracts, the really dense language of aviation treaties.
And a fight for accountability, a fight that would take these two passengers from that chaotic plane cabin all the way to the steps and then the bench of the highest court in Australia.
It really makes you ask, doesn't it? What happens when the harsh reality of physical injury crashes head-on into the carefully constructed world of international air law and, those rules airlines write for themselves that we rarely ever look at?
And that's precisely what we're diving deep into today. We've got the source materials, court documents, detailed judgment summaries, articles that track this case through the entire system.
Yeah, the whole paper trail.
Our mission is to unpack it all, reconstruct the journey, from that sudden, terrifying jolt in the sky right up to the final word from the High Court. We want to understand the human cost, absolutely, but also the legal strategy, the high stakes.
The twists and turns through different courtrooms.
Right, and the surprising, maybe even counterintuitive insights hidden in the complexity of things like the Montreal Convention and those airline tariffs. The stuff you usually just click agree on.
Without a second thought.
Right.
What were the Evanses really fighting for? How did Air Canada build its defense? And how did what seems like pretty clear language in a contract become the focus of years of intense legal argument?
Ending up with the High Court's maybe unexpected final say.
So to really get our heads around this, we need to sort of introduce the key players, the dramatis personae of this legal story.
Okay.
First, obviously at the absolute heart of it, Renae and Stephanie Evans, mother and daughter, passengers on that flight from Vancouver heading to Sydney.
And the turbulence hit them hard.
Really hard. Renae, the mother, suffered severe injuries, specifically a discogenic injury affecting 2 levels of her cervical spine and her neck.
That sounds serious.
It was, not just a strain. Serious enough that she needed major surgery, a disc replacement, and fusion. And on top of that awful physical trauma, significant psychological injuries too.
Understandably. And her daughter.
Stephanie was only 17 at the time. She suffered soft tissue injuries all through her spine, and perhaps just as lasting, severe psychological shock from the sheer terror of it all. They are the plaintiffs, the appellants later on, the people whose lives were just completely changed that night.
Seeking justice or at least compensation within this really complex system.
Then on the other side, you have the respondent, the defendant, Air Canada, the airline operating the flight.
And their initial stance.
Right after the incident, their public statements called the turbulence unforecasted and sudden. That framing was crucial from the get-go.
Positioning it as an act of nature, something unavoidable.
Precisely. Laying the groundwork for their legal defense, basically saying this wasn't our fault, and relying on those international treaties to potentially limit how much they might have to pay out.
Okay, so we have the passengers and the airline, then come the lawyers.
Absolutely. The legal teams navigating this complex path. For the Evanses, their fight was led by Shine Lawyers, an Australian firm that has experience in aviation cases.
And the barristers arguing in court.
In the Supreme Court, it was Richard McIlwain SC. But when the case went all the way up to the High Court, they brought in the very well-regarded Bret Walker SC.
Oh, Bret Walker, a big name.
A very big name. A top constitutional and appellate lawyer. People who watched him in court described his style as deliberate and profound. Really meticulous.
And their core argument, what was the thrust of it?
That Air Canada, through a specific clause in its own contract, its tariff, had basically agreed to remove the usual legal limits on its liability for these kinds of injuries. They'd waive their defense, essentially.
Wait, and opposing them. For Air Canada.
They had barrister J.T. Gleeson SC, Justin Gleeson, another leading silk, former Solicitor General of Australia. He was supported by Geo J. O'Mahony and L.G. Moretti.
So Gleeson versus Walker in the High Court.
Yeah, described as a legal spectacle in its own right. Two heavyweights of the Australian bar going head-to-head over the meaning of just a few words.
And Air Canada's argument championed by Gleeson.
Their line was that the crucial wording in their tariff wasn't a contractual promise to waive their defense. No, it was just descriptive language, trying to summarize the effect of the underlying international law, the Montreal Convention.
Interesting. So not a waiver, just an explanation.
That was their contention. And then overseeing all this, the judges.
Right, the arbiters.
It started with Justice Rothman J. in the Supreme Court of New South Wales. His initial take was really pivotal.
Then Air Canada appealed.
Yes, to the NSW Court of Appeal, heard by Justices Leeming J.A., Payne J.A., and Griffiths A.J.A.
And finally, the High Court.
The final stop.
Yeah.
The bench there comprised Chief Justice Stephen Gagler, Justices Stephen Edelman, Simon Stewart, Jacqueline Gleeson, no relation to Justin Gleeson SC, interestingly, and David Beach Jones. They had the final say on this really knotty legal question.
And the stakes here, we need to understand this, were huge, especially for the Evanses. This wasn't just about proving Air Canada was somehow responsible for the turbulence itself.
No, not primarily. It was fundamentally about how much compensation they could potentially receive for these really serious, life-altering injuries.
Because there's this international law, the Montreal Convention, that sets up a specific system, right?
Exactly. For passenger injury, it has this sort of baseline liability. It's set at 113,100 special drawing rights SDRs.
SDRs, what are those?
They're like an international currency basket used by the IMF. At the time of the case, 113,100 SDRs was roughly equivalent to about 240,000 Australian dollars per passenger.
Okay, so about 240K AUD, what does that threshold mean?
Well, below that figure, roughly $240 per person. If you're injured in an accident, and severe turbulence can count as an accident on an international flight covered by the convention, the airline is strictly liable.
Strictly liable.
Yeah.
You don't have to prove they were negligent or did anything wrong. The liability attaches just because the accident happened on their watch, on board the aircraft. They have to pay up to that limit.
Okay, up to $240, airline pays, basically no questions asked about fault. But what about damages above that? Renae Evans' injuries sounded like they'd easily exceed that.
Absolutely. And that's where Article 21, specifically Article 21, Paragraph 2 of the Convention comes in. It deals with damages exceeding that 113,100 SDR threshold.
And what does it say?
It says the airline's liability for damages above the threshold becomes potentially unlimited. However, and this is the crucial part, the airline gets a defense.
A defense?
Yes. They are not liable for damages above that threshold if they can prove one of two things. Either that the damage was not due to their negligence or other wrongful act or omission, or that the damage was solely due to the negligence or wrongful act of a third party.
So above the $240 K mark, the airline can potentially avoid paying more if they can prove it wasn't your fault.
Exactly.
Yeah.
This is often called the partial defense. Liability above the threshold is unlimited unless the airline successfully proves lack of fault. So it shifts from strict liability below the threshold to a fault-based system above it.
Okay, let me see if I've got this. It's like two tiers. Tier 1, up to about $240K the airline pays because the accident happened. Tier 2, for damages above $240K, the airline might have to pay unlimited amounts, but they get a chance to argue, hey, this wasn't our fault. If they prove that, their liability stops at the $240K threshold.
You've got it. That threshold isn't really a hard cap. It's a point where strict liability ends and the airline's potential defense based on fault kicks in.
Right. But there's another twist, isn't there? Something about airlines being able to change these rules.
Yes, and this became the absolute linchpin of the Evans' case. Article 25 of the Montreal Convention. It explicitly allows an airline to basically opt out of parts of this system.
How so?
Article 25 says a carrier may stipulate that the contract of carriage shall be subject to higher limits of liability than those provided for in this convention or to no limits of liability whatsoever.
No limits of liability whatsoever.
Exactly. This means an airline can, through its own contract terms, usually found in that dense document called a tariff, agree to pay more than the convention requires or even agree to have no limits at all. Crucially, They could use this power to voluntarily give up that Article 21.2 defense based on lack of fault.
Ah, okay. So an airline could say, you know what, even if he wasn't our fault, if the damages go above 240K, we'll pay anyway, no defense.
Precisely. They can contractually waive that defense.
And this is what the Evans' lawyers argued Air Canada had done in their tariff.
That was their core argument. They found a specific sentence in Air Canada's tariff that they believed was Air Canada activating this Article 25 power and saying, we waive the defense, liability is unlimited above the threshold, regardless of fault.
Wow. The difference is massive then. If Air Canada could prove no negligence, liability might cap around 240K per person. But if the defense was waived,
then liability could be completely unlimited. Given Renae's serious injuries, surgery, enduring effects, the potential damages could easily run into millions. It was a colossal difference hanging on the interpretation of that tariff clause.
So let's trace this journey through the courts. It all starts, of course, with that terrifying flight on July 11th, 2019, AC-33 over the Pacific.
Yeah, and those passenger accounts are just harrowing. The plane must have dropped about 100 feet. We all went up to the ceiling.
Imagine that feeling, weightless, then hitting the ceiling, another saying, the seat in front of me actually snapped and broke it. Just incredible forces at play.
And that awful image. Literally bodies on the ceiling. Sources mention maybe 37 people injured to some extent.
But for Renae and Stephanie Evans, these were definitely not minor issues. Renae's cervical spine injury, needing that fusion surgery. Stephanie's spinal injuries, the severe psychological shock for both. These damages were clearly going to be way over that 113,100 SDR threshold.
No question. And Air Canada's initial public statement, remember, calling it unforecasted and sudden.
Setting up that not our fault defense early on.
Exactly. Positioning it as something they couldn't have prevented, which is key for arguing against negligence later under Article 21.2.
So the Evanses, back in Australia, presumably injured and traumatized, decide to seek legal help. They go to Shine Lawyers.
Right, and Shine Lawyers then had to navigate this complex legal landscape. The main governing law in Australia is the Civil Aviation Carriers Liability Act 1959, a Commonwealth Act.
And that act does what?
Essentially, it takes the rules from the international treaty, the Montreal Convention 1999, and makes them part of Australian law for international flights connected to Australia. It's the bridge bringing those international rules into our domestic legal system.
So the Montreal Convention is the key international rule book here.
Absolutely. It was agreed by loads of countries to create a uniform, predictable set of rules for airline liability worldwide, replacing older, more complicated systems like the Warsaw Convention.
Trying to balance passenger rights and airline certainty?
That's the idea. And the crucial bits of that rulebook for this case were Article 17, which establishes the basic principle of liability for injury on board.
Okay.
Article 21, which contains that two-tiered liability structure we talk about, strict liability up to the threshold, and then the potentially unlimited tier with the airline's partial defense above it.
Right, the defense based on proving no negligence.
And Article 25, the game changer, the one that allows airlines to contractually agree to higher limits or no limits, effectively giving them the power to waive that Article 21.2 defense.
Got it. So, armed with this legal framework, the Evanses filed their case.
Yes. Proceedings began in the Supreme Court of New South Wales on June 28, 2021, almost 2 years after the flight. Their claims sought damages for their bodily injuries, relying on Article 17 as brought into Australian law.
And Air Canada's response?
Their defense, filed August 2, 2021, did exactly what you'd expect. They pleaded the Article 21.2 defense. They said, essentially, we are not liable for damages over the 113,100 SDR threshold if we can prove the injuries weren't caused by our negligence. Standard procedure under the convention.
But the Evans' team had found something they thought changed the game.
Exactly. Their reply, filed much later, February 18, 2022, dropped the bombshell. They pointed to Air Canada's own contract, document the International Passenger Rules and Fares Tariff.
The fine print.
The very fine print. And they zeroed in on one specific rule, Rule 105C1A.
And what did this crucial rule say?
It said, and I quote, where the Montreal Convention applies, there are no financial limits in respect of death or bodily injury.
Okay, there are no financial limits. On its face, that sounds incredibly clear.
It really does. And that was the Evans' entire point. They argued those 7 words were Air Canada using its power under Article 25 of the Convention to say, we accept unlimited liability above the threshold, we waive the Article 21.2 defense based on fault.
So the whole case, at this point, boiled down to, did that sentence mean Air Canada had voluntarily given up its most important defense for high-value claims?
That was the million-dollar question.
Yeah.
Or potentially multi-million-dollar question.
Recognizing this was the absolute crux, the parties agreed this needed sorting out first.
Yeah, very sensibly. They asked the court to decide the meaning of this tariff clause as a separate preliminary question before they got into a potentially huge fight about negligence and the actual amount of damages. Orders for this were made in late 2022 and mid-2023.
So stage one, just tell us what this sentence means.
Exactly. And the first judge to rule on this was Justice Rothman J. in the NSW Supreme Court. His decision came down on December 12, 2023. It was a big win for the Evanses initially. Justice Rothman accepted that Article 25 allows airlines to agree to no limits. He looked at the words in Rule 105C1A, there are no financial limits, and he found them clear and unambiguous.
Clear and unambiguous. Strong words.
Very. He said giving those words their natural and ordinary meaning, especially considering Article 25 existed, meant they did constitute a choice by Air Canada to remove the liability limits and, implicitly, the defense that went with them.
So judge number one says, yep, plain English, no limits means no limits, defense is gone. That must have been a huge boost for the Evanses.
Absolutely massive. It potentially opened the door wide for them to claim full compensation for Renae's very significant injuries without needing to prove Air Canada was negligent.
But Air Canada wasn't rolling over.
Not a chance. They immediately appealed Justice Rothman's decision to the NSW Court of Appeal. The appeal was heard pretty quickly, June 5, 2024, and the judgment came just over 2 weeks later, June 24, 2024.
And the judges there were Leeming, Payne, and Griffiths. What was Air Canada's argument on appeal? Did it change?
The core argument was the same. Justice Rothman got it wrong. But they really leaned into the context argument. They insisted you couldn't just pluck that one sentence out and ignore everything around it.
Okay, what context did they emphasize?
They argued Rule 105C1A wasn't a waiver under Article 25 at all. It was just descriptive language trying to explain the Montreal Convention's setup, which does have an unlimited potential upper tier, but that tier is still subject to the airline proving it wasn't negligent. They stressed reading the tariff as a whole document, considering the convention itself, which is law, and the tariff's purpose, which was partly just to tell passengers about the rules.
Right, because regulations required them to publish these tariffs.
Exactly. And they made a really strong point by comparing this rule to another rule in their tariff, Rule 105B1. That rule dealt with the older Warsaw Convention.
Okay.
In that rule, when Air Canada did want to give up certain defenses available under Warsaw, they explicitly used the word waive. And they referenced the specific Warsaw Convention article that allowed the waiver.
So they were saying, look, we know how to waive a defense clearly in this document. We use the word waive and cite the article. We didn't do that here in Rule 105C1A for Montreal.
Precisely. The absence of the word waive and the lack of any reference to Article 25 in the disputed clause was, they argued, very telling. It showed they didn't intend to waive the Montreal defense.
That's a compelling textual argument. What did the Evanses say to counter that?
They essentially stuck to their guns, backing Justice Rothman. They argued the words no financial limits were just so plain, so clear. Bret Walker SC would later argue in the High Court clearer words could not have been used, that they had to mean a waiver under Article 25. They pushed back against Air Canada's attempt to muddy the waters with complex treaty interpretation when the contract language seemed simple.
So the classic legal battle. Plain meaning versus the bigger picture, the context. How did the Court of Appeal rule?
They sided firmly with Air Canada. They allowed the appeal, overturned Justice Rothman's decision on this point.
Wow. So they disagreed with the first judge. Why?
Justice Leeming gave the lead judgment, and the others agreed. He really hammered the point about context. Yes, Article 25 allows a waiver, but the court found Air Canada hadn't actually done it here.
What was the key reasoning?
Context, context, context. Leeming JA said you have to read the tariff rule not just on its own, but within the whole tariff document and the external regulatory context. He found the main purpose of Rule 105C seemed to be fulfilling Canadian regulations that required airlines to tell passengers about liability limits under different legal systems, like Montreal. It felt more didactic, like it was teaching or describing, rather than actively changing the airline's legal obligations.
So more informational than contractual modification.
That was the view. The court also pointed to other bits of Rule 105C that sounded like summaries, and they highlighted another clause, Rule 105B, which said the Montreal Convention rules are fully incorporated and prevail over any provisions of this tariff which may be inconsistent.
Meaning the convention's rules, including the defense, were supposed to trump anything seemingly contradictory in the tariff.
Exactly.
Yeah.
It suggested Air Canada's intention was to stick to the convention's scheme, defense included, not break away from it.
Okay, that's strong. Was there anything else?
Yes. Perhaps the killer point for the Court of Appeal was Rule 105(c)(4). This clause came immediately after the no financial limits sentence.
And what did 105(c)(4) say?
It basically restated the airline's defense based on lack of negligence. It mirrored the language of Article 21(2) of the Convention. Justice Leeming explicitly said this clause confirmed that Air Canada had no plans to waive the R2102 partial defense.
Whoa. So right after saying no financial limits, the tariff essentially said, but remember, we still have our defense if it wasn't our fault.
Pretty much. It made the Evans' interpretation that the first sentence waived the defense look internally inconsistent when read alongside the very next sentence.
That does seem contradictory.
It did to the Court of Appeal. So you combine that internal contradiction with the lack of explicit waiver language, unlike elsewhere in the tariff, the failure to mention Article 25, and the clause saying the convention prevails. The court concluded Rule 105(c)(1)(a) wasn't a waiver.
So what did they think no financial limits meant?
They concluded it was just describing one feature of the Montreal Convention's upper liability tier, the fact that there's no ultimate monetary cap on the amount of damages if the airline is found liable in that tier. But it wasn't waiving the condition for liability in that tier, which includes the airline's defense based on lack of fault.
Okay, a subtle but crucial distinction. A description of the potential maximum amount, not a waiver of the conditions to get there.
That was the Court of Appeal's finding, a huge setback for the Evanses. It meant Air Canada could still use the Article 21(2) defense and potentially limit their payout to that $240 K threshold per person.
But the Evanses didn't stop there. They sought leave to appeal to the highest court in the land.
That's right. They applied for special leave to appeal to the High Court of Australia, and on October 10, 2024, that leave was granted. The stage was set for the final act.
The High Court in Canberra, 5 justices, and the 2 legal heavyweights facing off. Bret Walker SC for the Evanses, Justin Gleeson SC for Air Canada. Must have been quite the scene.
Described as a spectacle, yes. The final arguments before the ultimate arbiters.
What were the final pitches to the High Court? Did the arguments evolve again?
Bret Walker SC for the Evanses really doubled down on the plain meaning argument. He attacked the Court of Appeal's reasoning, insisting that the words no financial limits in Rule 105(c)(1)(a) were just fundamentally clear, unambiguous contractual language.
Clearer words could not have been used.
Exactly. He argued they plainly stated the absence of any financial cap and should be read as a waiver under Article 25, just as Justice Rothman had originally found. He basically accused the Court of Appeal of getting lost in the weeds of complex treaty law and ignoring the clear words of the contract.
And Gleeson SC for Air Canada.
He robustly defended the Court of Appeal's decision. His argument was all about context. He stressed this wasn't just any old contract, it was a tariff, required by regulations, deeply intertwined with an international treaty that has the force of law in Australia.
The Montreal Convention again.
Always. Gleeson argued Rule 105(c)(1) was simply an accurate description of the effect of the Convention's liability scheme. Yes, that scheme has an upper tier with no financial limits on the amount, but it also provides the airline a defense in that tier. He argued the clause described the lack of a monetary ceiling, not the lack of the defense.
The same subtle distinction as before the Court of Appeal.
Exactly. But he went further. He argued that interpreting the tariff properly required understanding the Montreal Convention, using established international law principles like those in the Vienna Convention on the law of treaties. He even took the High Court judges through the travaux préparatoires, the drafting history of the Montreal Convention itself.
Digging into the treaty's origins, what did that show?
The travaux showed the drafters wanted to get away from the old Warsaw Convention's low, fixed caps. Their solution was this 2-tier system. Strict liability up to a point, then an unlimited financial tier above it. But crucially, the drafting discussions showed the intent was that this unlimited tier was still subject to the airline, proving it wasn't negligent the Article 21(2) defense. The threshold was the switch point.
So the history supported the idea that unlimited applied to the amount, but the defense still existed in that tier.
That was Gleeson's argument. Against that historical backdrop, Rule 105(c)(1)(a) saying no financial limits was perfectly consistent with the convention's structure. It accurately described the lack of a financial ceiling in the upper tier, but it didn't touch the defense.
And he presumably hammered the points about the surrounding tariff rules again.
Absolutely. He stressed the importance of Rule 105c4, right next door, preserving the defense, and the contrast with the explicit waiver language used for the Warsaw Rules elsewhere in the tariff. He argued the Evans's interpretation led to capricious results and made the tariff contradict itself and the convention.
So the High Court had to decide was no financial limits, an active promise by Air Canada to pay whatever the damages were, regardless of fault, above the threshold, or just a passive description of the theoretical maximum liability if they couldn't prove lack of negligence.
Waiver or description? That was the ultimate question.
And the High Court's decision, delivered May 14th, 2025. What did they rule?
Unanimous decision. They dismissed the Evans's appeal.
Unanimous. Wow. So they agreed with the Court of Appeal.
Completely. They agreed that, yes, Article 25 does give airlines the power to waive the defense, but they found that Air Canada had not, in fact, done so in Rule 105c1a.
And their reasoning, similar to the Court of Appeal.
Very similar, but perhaps even stronger on the need for context. They firmly stated that interpreting Rule 105c1a required looking at its full context and purpose. They emphasized that even though the claim was under Australian law, the underlying treaty, Montreal Convention, had a specific meaning in international law, governed by international principles, and Australian law just incorporates that meaning.
So international law context was key.
Absolutely. The High Court found the context and purpose of the rule were clearly to describe the effect of the Montreal Convention's liability scheme, including both tiers and the defense in the second tier, not to create some new contractual right that waived a defense explicitly provided by that convention.
And they agreed on the significance of the other clauses.
Yes. They highlighted the importance of the surrounding provisions, especially Rule 105c4 restating the defense. They also noted the absence of explicit waiver language, contrasting it with its use elsewhere in the tariff concerning the Warsaw Convention. This contrast, they found, clearly indicated Air Canada did not intend to waive the Article 21(2) defense here.
So the final word from the highest court is, despite sounding plain, no financial limits, when read in its full legal and contractual ecosystem, just meant there's no ultimate monetary cap in the upper tier. But the airline's defense, based on lack of fault, still applies to that tier. It didn't waive the defense itself.
That's the authoritative interpretation now. The words describe the potential ceiling amount, not the conditions for liability, which include the crucial defense.
So after all that, what does this mean for Renae and Stephanie Evans now? Where does it leave them?
It means the battle over the tariff's meaning is over, and Air Canada won that legal point. Air Canada can rely on the Article 21(2) defense.
So the case isn't necessarily over, but the path has changed.
Exactly. The case will likely go back now, probably for a trial, but the central question shifts. It's no longer about interpreting the tariff, it's about whether Air Canada was negligent.
Back to the cause of the turbulence and Air Canada's actions.
Precisely. Air Canada now has the opportunity to try and prove that the clear air turbulence and the Evans's resulting injuries were not due to their negligence or that of their crew or agents.
And if Air Canada succeeds in proving lack of negligence,
then their liability will be capped at that $113,100 SDR threshold per passenger, the roughly $240,000 AUD figure, even if the court assesses the Evans's actual damages to be much higher.
But if Air Canada fails to prove lack of negligence, if the court finds they were at fault,
then their liability would be unlimited, up to the full amount of damages the court determines the Evanses suffered from their injuries.
So years of litigation focused on 7 words in a tariff, and now it circles back to the fundamental question of fault, just framed within the Montreal Convention's structure.
That's right. The complex preliminary legal question is settled, decisively in Air Canada's favor on that point. The next potential chapter is the factual one. Was Air Canada negligent regarding this severe turbulence event?
Okay, let's zoom out then. After tracing this whole dramatic legal saga, what are the key takeaways for us, for the listener?
Well, first, I think it's a really stark reminder that international air travel operates under a very specific, quite complex, multi-layered legal system set up by treaties like the Montreal Convention. It's not straightforward.
That tiered liability system, strict up to a point, then fault-based above.
Exactly. It balances different interests. Second, airlines can choose to offer more protection. Yeah. They can agree to higher limits or no limits under Article 25, effectively waiving their defense. But this case shouts from the rooftops that if they want to do that, especially giving up a valuable defense, the language in their contract, their tariff, needs to be incredibly clear and unambiguous when read in its proper context.
Context is king.
Absolutely.
Yeah.
That's the third big takeaway. The High Court couldn't have been clearer. You cannot just read a sentence in isolation, no matter how plain it seems. The surrounding clauses, the document's purpose, the underlying law. The whole ecosystem matters in figuring out what words truly mean legally.
And finally, the specific result here shows that in action, no financial limit sounds simple, but the courts looked at the context, the rest of the tariff, the convention, the regulatory purpose, and decided it was descriptive, not a waiver. It described the lack of a cap on amount in the upper tier, not the lack of the defense applicable to that tier.
It's a fascinating journey, isn't it? Shows how one sentence, maybe drafted years ago for regulatory reasons, can spark years of debate among the sharpest legal minds and end up before the High Court. It certainly highlights the Evans family's determination to seek accountability.
And the very robust defense Air Canada mounted, playing strictly by the complex rules of the convention.
Definitely. Which brings us back to you, the listener. Maybe you're booking flights right now. Why should this case, this deep dive, matter to you?
Well, for starters, it really pulls back the curtain on the invisible legal framework that's wrapped around you every time you fly internationally. Those treaties aren't just abstract things. They define your rights and the airline's duties if something goes wrong, like on AC-33.
And it hammers home the importance of the fine print. Those airline tariffs, the conditions of carriage we all ignore, they are part of your contract. And as Evans v. Air Canada vividly demonstrates, the exact wording and how courts interpret it in context can have huge consequences for whether and how much compensation might be available.
It's a sobering reminder that getting compensation for injuries on international flights isn't simple. It involves navigating this really complex legal world.
It really does. The High Court has now given us a definitive reading of this specific Air Canada tariff clause. That particular debate is settled. But thinking about this whole saga, does it actually make it clearer for an average passenger trying to understand their rights by, say, reading an airline's tariff online?
That's a good question.
Or does it maybe just underscore how inherently complex it all is? Does it suggest that the real meaning of the fine print at 36,000 feet is still pretty opaque for most travelers, needing expert legal interpretation to truly grasp that balance between passenger protection and airline limitations? Something to perhaps ponder the next time you click, "I agree" on those terms and conditions.